समृद्ध कुटुंब से Yes, Ms. Ramakrishnan.
So I was saying,
Yep.
yes,
Notebook.
Your Lordship, that
Notebook.
the spoken or unspoken assumption is that Article 370 is temporary, lying in wait for a greater integration. I'm saying that that view is completely fallacious because integration is not a measure of how much control the center has.
What did you say at the end? Integration is not a measure.
It's not measured by how much control the center has. It is not a function of central control or power. And it would be pernicious to say that people in the Union Territory are more integrated than, say, people in Western the people. And also, as your Lordship said in Indira Nehru Gandhi, that this shared sovereignty is really a system of checks and balances. Equally, it is so between the center and the state. So Article 370 also reflects a system of checks and balances, central power and the power of the state. State of Jammu and Kashmir. Because the people are never completely excluded from any process, although they have entrusted their sovereignty. This is what the judgment says. So the checks and balance system is what expresses the political sovereignty so that nobody encroaches. So Article 370, in that sense, the will of the people of J&K permeates every part of Article 370, 371, and 371 survives. It is not, I do not endorse the view that the whole article has come to an end. 371, the concurrence, and I'm not saying it's binding. What Iyengar's speech is certainly not binding, but it reflects the fact that despite there being a titular monarch, the power of concurrence, even when there was no state legislature, was given to the largest party because it was a democratic step. And that is why 371, both for concurrence and for consultation, the state government is emphatically defined as a governor advised by a council of ministers. Even the CO 272 says that. Whether by mistake or what, I don't know. So a governor who is not advised by a council of ministers is not recognized by 370. And therefore, any CO issued during a period of president's rule is simply not competent. Actually, I checked. In 70 years, all of 5 COs have been issued during president's rule or governor's rule. 1 in 1986 and 4 extending the term of presidential proclamation in the year between 90 and 96.
What's the number of the 1986 here?
129, CU 129.
And what was it relating to?
It was relating to, I think, the power under Article 249. It was a temporary provision. And it was challenged, but it was never tested. What I want to say is this has never been tested for constitutionality. It was challenged in the Delhi High Court, but eventually it was dismissed as infructuous. So there is no ruling. So despite the peremptory terms of Article 370, whether a non-responsible government, a government not responsible to the state legislature, could exercise this power of concurrence has never been tested. And I'm saying it cannot be done. I could hand over the 5 COs instead. And therefore, Article 356, which is not covered by a non-obstantive clause, 370 is. Its special terms, its sui generis power to the state government is a power. And it is not a function that can be taken over by the central government. Function is a duty. Power is a discretion. It's a sui generis power given to a responsible state government and consciously given to a responsible state government. It cannot be taken over under Article 356, which is subservient to Article 370 on the sheer terms. And even a responsible state government's consent will not suffice for changing the terms of the article. It has to emanate directly from a constituent assembly. A constituent assembly signifies an exclusive agency, exclusively devoted and representative of the people of Jammu and Kashmir, fully and exclusively. So, if a change has to occur, it has to occur by an age, emanate, the recommendation has to emanate from an agency which is equal in mandate and stature to a constituent assembly. This is how the will of the people of Jammu and Kashmir on a principle of shared sovereignty is reflected in Article 370. And that agency, which must be equal, today there is no constituent assembly. After 57, there is no such agency on the horizon. If it has to be contrived, it will either be through political will, as they say, the hour, if I may paraphrase, the hour may produce the means. Else, whether it can be contrived in terms of the existing constitution, I do not think Article 368 will apply. Because the terms of Article 370 is this article and Article 1 will apply. So the limitations are there in the article itself, but whether it applies or not, that's not what has been done. Some thought and sensitivity and democratic stirrings are required to think of an agency which could express this will. But one thing is clear, it cannot be any agency of the centre. It cannot be, because a democratic pact is between two power centers of sovereignty. And this is not as though they're setting up their wills against Indian sovereignty. As part of Indian sovereignty, there's a checks and balances system. There's the state and the center. So how can the center exercise the power which has been given to the state? It's, on the face of it, it's absurd. So the constitutional intent is clear. It cannot be any agency of the center. The will of the people of Jammu and Kashmir is integral to the mode of governance specified in Article 370. And a process which has systematically, with malintent, erased the will of the people can never legitimately affect Article 370. And their will has been systematically erased in this fashion. I quickly give the run-up. 20th of June, the governor's rule is imposed because and it's stated in the order that because one party has withdrawn and no other political party is ready to form the government. This is why governor's rule was imposed, not because of anything else, not because there was a security issue, not because the state was in any danger. Because no political party was willing to form the government, then what earthly reason had the governor to dissolve the House within 30 minutes of two agencies saying we are ready to form the government? Two political parties. One, a letter, it's what page is this? I'm not going to read it. Page in the petition compilation.
Mr. Sibal has already taken us.
Yes, I don't want to read it again. So 56 out of 87 MPs stake a claim. The governor is not there. We cannot determine where the governor is, but we can inform him. It is on record that the secretary has acknowledged the WhatsApp message. He does not answer the phone, fax doesn't go through. He is informed on WhatsApp, and a public tweet tagging the governor is issued. By 8:16, this is done, and by 8:57, we are notified that the House has been dissolved. What earthly reason has a governor to dissolve a House when governor's rule was imposed only because no political party was ready to stake a claim? And when political parties are ready and willing to stake a claim, what business has the governor to say, I'm not here, I'm not there? Then in this state of affairs, there is a proclamation of President's rule. And the president usurps the power of the state government under Article 371. It is not permissible under Article 356 because it only allows him to take over the functions of a state government, not sui generis powers, protected by a non-obstant clause. And what need has a power? He has executive powers to do whatever has to be done on a regular basis in a state government. And temporary legislative powers. Where is the need for this extraordinary power? It is not contemplated. And then we are told the situation was not okay for elections to be held. That means that situation must only be attributed to the governor and the president. Because until then, the reason was that no political party is coming forth. So this, I'll finish. So this is malice and this power under Article 356, which is really subject, legislative acts there are subject to a post-appraisal by the state legislature. This power is ironically used to destroy all possibility of a legislature. So the people of Jammu and Kashmir don't have a legislature when the act is contemplated of abrogating Article 370, and it is ensured that they do not have any future legislature either. And my friends want your lordships to believe that this is an expression of the will of the people of Jammu and Kashmir. My lords, this is, a self-proclaimed agent through a series of proxies, strangling the principle and telling your lordship this is not murder but suicide. This is really that. And this CO 272 is not only legally untenable because of what I said about Article 371 and the sui generis power. Only one page I want your lordships to see. There is this public functionary, volume 13, page 435.
Of the documents?
Just 1 second.
Here is a governor who gives video interviews. I'm aware that strictly a newspaper report is not evidence. It is not evidence in the sense that you cannot base a criminal conviction on it. But when a public functionary, former
What is this at page?
This is a interview given, a video interview given by the governor who had dissolved the assembly, not the person who imposed governor's will. And also, it's supposed to have given concurrence for CO 270.
Page you are referring to?
He's still lingering on the.
13 pages.
This is an interview he gave to Wire's current.
Why I am interrupting?
It's part of the compilation.
No, this is an impediment filed in 22, never listed, for the first time being listed. Therefore, I am asking what?
Sorry?
Yes, which part do you want us to
I just
see?
want to read from the middle. So, Karan Thapar, so really you had no idea. He had no idea on the night of August 4 what was coming. And he has given concurrence like this. Satyapal Malik, absolutely nothing. I did not know anything. I was merely called by the Home Minister one day prior saying, Satyapal, I'm sending a letter tomorrow morning. Please get it passed by a committee for 11 tomorrow and send it to me. The whole world is aware of this. We cannot sit in an ivory tower and behave it never happened.
Post facto statement.
Post facto statements. Only at that level your lordship may consider it as post facto statement. Obviously, before that he didn't even know, he could not have issued a statement. So this is people's will. Only two other points. This, your lordship will have to see Article 370, CO 272. It is true that in 1954, just 2 points and I'll finish. CO in 1954, when the Constituent Assembly was functioning and also doubling as a legislative assembly, for a brief while there was a CO saying references to the Legislative Assembly in the Constitution would be read as including a reference to the Constituent Assembly of Jammu and Kashmir. That was a situation where this made sense because there was a corresponding body which was functioning as a legislative assembly. But
This was
what
in
they did-
1954, Ms. Nitya, this was in 1954, you
Yes.
said? She said for a brief period in 1954, when the Legislative Assembly.
Yes, there was a CO, which said, page 18. I'll read it.
Volume?
Documents volume 3, page 8.
Sorry, tell me again.
Documents volume 3, page, PDF page 18.
Oh, the CO 54.
CO 50.
CO 48 in 1950.
Sorry, CO 48 in 1950.
Let's just see that for a second.
So that said, my friends are relying on it, saying it was done then and we can do it now.
No, that's to appreciate your solutions.
References,
In page.
1 second.
References.
What is the page?
references,
What is the page number?
page number, internal page 18,
No, this is PDF page 8.
PDF page 8.
PDF page
18,
18.
1.
Oh, 18.
This was with reference to Article 367.
Yes. It was done under Article 367. So they're saying it's been done before and we can do it again. And I tell you, Lordship, why that's completely fallacious.
Which clause is that? Ah.
Subclause 4D. References to the legislature or legislative assembly of the said state shall be construed as including references to the constituent assembly of the said state.
Just 1 second.
Was this withdrawn later on? No.
Yes, it was temporary and then it was changed. Once the constituent assembly stopped, then it was just legislative assembly.
No. Was there a CO issued?
Yes, the CO issued. CO 1958 removed.
The 1958 would be post Constituent Assembly.
Yes. There was no constituent assembly at that time. So,
Till the Constituent Assembly was there, this concept of 4D was available.
yes.
That's it. Removal this page is at page 26, your lordship. I mean, note that.
What's the CO number?
You 56 in 1958.
I'm saying that makes sense because there was a constituent assembly functioning which doubled as a legislative assembly. What they have done now, my point is
I'm sorry, just what is the page number of CO number 56?
28,
26.
26,
26.
26.
And 26.
This would be clause 7C, is it? In para 14 relating to part 19, C in clause C,
Omitted.
subclause D shall be omitted. Yes.
But what they've done by way of CO 272, aside from the argument that they could not have done it because there was no power under 371 with the center or with the governor. The absurdity, you see, it is as an exercise under Article 367, it leads to a semantic absurdity. Now, I'll tell you, Your Lordship, why. Your Lordship will just take a look at Article 370. I know Your Lordship have read it many, many times. I just want to show. Now, clause 3. It says, provided that the recommendation of the Constituent Assembly of the state referred to in clause 2. And clause 2 refers to a Constituent Assembly for the purpose of framing the constitution of the state. Now we're making an argument on pure elementary logic. There is a reference to a Constituent Assembly as referred to in clause 2. Clause 2 remains on the book for reference, and it refers to a Constituent Assembly for the purpose of framing a constitution of the state. So there is a relationship of identity between what the Constituent Assembly in clause 3 and the Constituent Assembly in clause 2. A is A. And so long as these two remain on the book, you cannot now bring by way of an interpretation that A in 3 is not A. Because what CO272 says in clause 3 alone, even what is referred to in clause 2 becomes something else, non-A. So long as this is there for reference, you can't include clause 2 and say it means something else. It's a logical absurdity. It's a semantic absurdity. It cannot, A is either A. A cannot be A and not A at the same time, but that's what they're trying to do.
At this point, we've got
Yes. Otherwise, the only way this exercise would have been valid is if they had, in fact, what they have attempted to do is they've removed all these words and substituted legislative assembly for it. In actual effect, that's what they've intended to do, which is an amendment. It cannot be an interpretation. And aside from that, even otherwise, A equals not A, Constituent Assembly is not Constituent Assembly. Governor who should act on the advice of Council of Ministers equals governor who is bereft of a Council of Ministers. The entire exercise, my lords, is full of Carroll and Lewis Carroll parallels. The whole thing is an exercise in absurdity.
All right, thank you.
And one last, and I have referred to Humpty Dumpty, I don't want to read it again. Changing meanings after the event, and that is it. And one last thing I want to tell your lordship, that this argument, even if Jammu and Kashmir flows with milk and honey, the argument that in order to secure people their constitutional rights and development, we have to destroy their entity, we have to destroy their statehood, that is the argument taken, and that cannot be countenanced regardless of anything. And one other, which is not a legal submission, and I'm not referring to facts, I'm winding up with this. In October 2019, with a friend, I visited the valley. And I was able to do it because I'm used to traveling unobtrusively, not because people were not stopped. The one name that resonates in the valley with faith is that of Mahatma Gandhi. They remember him as a man who lived and died for his word. Somewhere, that legacy must be kept in mind while deciding this time. That's all.
Thank you, Mr. Samshi. Dr. Goswami? You have a formulation, Dr. Goswami? You have a formulation on paper, what you're going to be submitting?
I'm sorry,
You
Manoj.
have a formulation on what you're going
Yes,
to have?
yes, Manoj, and
Let's have a look at it.
we've submitted the note, Manoj. I think it's page 4 to 5 of your compilation, volume 5. Page 4 to 5, volume 5. It's a 2-page note. My lords have it?
Yes.
My Lord Justice Sureka?
Useful.
Yes. My lords, yesterday, my Lord the Chief Justice had posed a question to Mr. Dwivedi that can you look to the statement of a drafter, a member of the Constituent Assembly, and accord it as being enforceable on the will of the people. And it was a very important question. Volume 5, which only has the 1-pager or 2 pages that your lordship had asked for yesterday. So it should be 14, 20 pages between all of us, my lords. Not just me, my Lord Justice Khanna, between all of us. I saw that look of shock and horror on my Justice Khanna's face.
Yes.
My effort neither to shock nor horrify, my lords. So this was the question posed by my Lord the Chief Justice yesterday. And it's a particularly important question because one, and I'll just formulate the proposition, because one, in this case, you have not one but 2 constituent bodies. So in many ways, it is unique to India's constitutional founding because it is the only state with its own distinctive constituent assembly. 2, it forces upon us this seminal constitutional question. Can the Constitution of India be altered in ways opposed to her founder's constitutional intention? And I'm not saying a drafter's opinion. I'm not saying a debate within the Constituent Assembly. I am saying, can it be altered in ways opposed to her founder's constitutional intention? When we think of this country's founding at a time of partition, from 46 to 49, our Constituent Assembly is drafting our Constitution. At the same time, we know what is happening in Jammu and Kashmir. Ms. Ramakrishnan alluded to that. The country's first Prime Minister, giving his speech in Hindi, said, "We are a nation whose land is strewn with blood. खून से रंगा हुआ ये ज़मीन." That is our constitutional founding. So my first proposition is this. There are certain seminal founding moments for any constitution, but more specifically Indian constitutionalism. Why are those seminal founding moments important, crucial, significant while interpreting the constitutions as your lordships will? It is because my lords have walked the path of transformative and expansive constitutional interpretation. And your jurisprudential moorings, with great respect, derive their legitimacy, their integrity, and their intellectual rigor from these founding moments, from our drafters' constitutional intention. If my lords had chosen since the 1970s a different path of minimalist interpretation, of limited review, then we would not have to worry about constitutional founding moments. But your lordships have embarked on this methodology of expansive and transformative constitutionalism. And thank heavens for that, because that goes back to the needs of our difficult founding. The creation of this country, two constituent assemblies, and also the unique brand of federalism that was envisaged by our founders for the state of Jammu and Kashmir integrated with the Union of India. And it's not just Article 1 and Article 370, which is part of that constitutional intention. It is much more than that. It is the specific provisions, and I'll take you to them very briefly. My lords have read it. I'll just refer to them. It is the specific provisions of the Constitution of Jammu and Kashmir, Article Sections 4 and 5. It is the specific provisions of territorial integrity of the state of Jammu and Kashmir that our founders promised and the Jammu and Kashmir Constitution recognized in its constitutional text. Such territorial integrity was not promised to any other state. This is all part of the founding constitutional intention. Now, in the 1960s, on an aside, my lord, when Thurgood Marshall was asked, why is it so important to have Brown versus Board desegregate America? He responded saying that it is not about their humanity, it is about our humanity. So today I present to my lords a different version of that. It is not simply about that constituent assembly. It is about the promises of our constitution assembly. It is about that legacy of interpretation that my lords started 4 decades ago. That is what this founding movement is about. That is what this model of federalism is about. That is what the intricacies of this model of federalism that embraced this version of what Ms. Ramakrishnan called shared sovereignty. That is part of India's federalist structure. Now please see, my lords, may I take my lords to section 4 of the Constitution of Jammu and Kashmir 1957, and the second proposition is this, and it's in the note. The abrogation of Article 370 has vitiated the unique internal sovereignty guaranteed by both constituent assemblies of Jammu and Kashmir and India. And this is in the middle of the note, my lords. So part 2 of the Constitution of Jammu and Kashmir categorically retains internal sovereignty with the state, along with residuary powers to the state government. This is unique to Jammu and Kashmir and distinct from the rest of India, where residuary powers under Article 248 is vested with the Union Parliament. And to this, my lords have sections 4 and 5, but 4 simply says this. It provides that the territory as under 15th August 1947, under the sovereignty of the ruler, that territory is comprised of the territorial integrity of the state. And that territorial integrity of the state is guaranteed to be protected. And section 5 simply says this. It provides that the legislative assembly of the state and all executive and legislative powers, so the legislative assembly of the state is vested with the residuary powers. Now this branch of the vesting of the residuary powers, the legislative residuary powers with the state assembly is unique to the state. So whether we want to display that in a conventional setting, a conventional that only external sovereignty has been surrendered by the state in terms of Article 371, and that's a sub-proposition, and internal sovereignty is retained by the state, or whether we want to say that this is shared sovereignty between the state and the union, between the two constituent assemblies. Either which way, and my lords have heard arguments speaking to both those ideas, but either which way, this brand of sovereignty is unique to the state of Jammu and Kashmir, and it is especially important in appreciating the unique federalism that is ascribed to the state in the federalism that speaks to India. My lords, on this note, I won't take you to the speeches, but on this note, we've just made 2-3 references, my lords. The speech of Kotwal Chunilal during the Constituent Assembly debates of Jammu and Kashmir, and your lordship will just mark that. And that is in the volume compilations. I'll just read a line from that. And he makes only 2 points. That the territories as on 15th August 1947, which were under the sovereignty of the ruler of the state, that is what the state will comprise. And within that, the state will have a legislative assembly and a legislative council. So dual houses and territory ascribed and guaranteed and promised. This is part of the founding. And all of that is marked, my lord, so I won't trouble my lords with it. Now the fourth proposition, my lords. The abrogation of Article 370 and the subsequent Jammu and Kashmir Reorganization Act 2019 by abolishing the bicameral legislature of the state has further violated the unique legislative autonomy secured by the state of Jammu and Kashmir. And this is just on top of page 2, my lords. Now for this, my lords, I just take your lordships to sections 46, 47 and 50 of Constitution of the state of Jammu and Kashmir. And my lords, that's in volume 2.
We have it here actually in the note itself, it's the section 46.
It's in volume 2, my lords, of the documents. Now,
46 is at
section
page 5.
46, my lords, pertains to the legislature for the state. There shall be legislatures for the state.
Bicameral legislature, both the legislative assembly as well as the council.
Yes,
It is expected in the
Again, by
the Chief Justice said.
yes, my lords. But my lords, what is important and interesting about this legislative model is that section 47 and section 50 provide for the composition of the legislative assemblies, the assembly and the council. Now, the reason why I'm belaboring this is because the composition speaks to a unique, my lord, Justice Sudhakant has that. The composition speaks to a unique regional model of governance. And that unique regional model of governance was only ascribed to the state of Jammu and Kashmir. So 46, 47 and 50. 47 provides for the composition of the legislative assembly and 50 provides for the composition of the legislative council. Yes, madam. Yes, madam. Now, section 50 of the Constitution of Jammu and Kashmir has unique requirements of this composition. And this shows a thoughtful regional understanding of the state. The Legislative Council is intended not only to have members from districts, but municipal councils, town area committees, panchayats, so on and so forth. Now, this is a very different understanding from Article 171 of the Constitution of India, which provides for legislative councils of a different kind. I just read, my lords, Article 171. Article 171 speaks to the composition of legislative councils. Total number of members, my lords, of each council shall not exceed. Now, subclauses 3 and 4. These are only specialist qualifications. The idea of 171 is not to provide for representation by region, but only to have specialists or memberships of members from specialist institutions.
Governance now in the constitution has come in different fashion. It was not prevalent then. So possibly the thought process at that time by creating the bicameral houses was to provide such representations from the government. But the Indian constitution has also changed over by inclusion of that.
My lords, the reason why I'm showing these distinctions, and my lord is very correct. But the reason why I'm showing this is that there was a method, an intention on how to keep, one, how to recognize the state, two, how to bring the diversity within the state together.
Character from a base level.
Yes, and diversity of regional representation, the only legislative council which had reservation on religious grounds, Sikhs had seats. Very unique. So there was an understanding of the people who knew the area best, that there would be a certain regional representation to hold together Jammu, Kashmir and Ladakh. There is no other legislative council which is thinking through regions, which is thinking through minority representations in this form. So when you take that area and divide it up and chop it up into 2 union territories, you take away all representation from Ladakh.
You got the point. Thank you. Anything else?
Yes, my lords. Just two brief points. So, my lords, following the abrogation of 370 then and subsequent state reorganization, the Legislative Assembly, 111 members, and the Legislative Council, 36 members, were dissolved. And then you had the state conversion into 2 union territories. Now, of course, Article 169 of the Constitution of India provides for a mechanism of the abolition of legislative councils. I'm saying this, my lords, because it is not as if only 370 has been miraculously removed and ejected in ways violative of constitutional intent. It is that everything that has happened has been contra the Constitution of India, including, for instance, the dissolution of this Legislative Council, which was envisaged by our framers. The Legislative Councils are meant to be dissolved in a certain manner, but certainly not in this fashion. And that constitutional intention of a recognition of identity, of a recognition of representative democracy, of a recognition of unique federalism extends to all of this. So you are not just running roughshod over 370, you are running roughshod over the small, how you dissolve a legislative council, and the big, how you don't hold elections for the last 4 years.
What is the next point? What is the second point?
Yes, my lords. Now, my lords, a small point is that prior to the impugned actions, Ladakh had 4 MLAs and 2 MLCs. It also has
You said Ladakh had 4 MLAs
Ladakh had 4 MLAs, my lords,
and
2 MLCs. 4 MLAs after the delimitation in 1995 and 2 MLCs pursuant to Section 50, my lords, of the Constitution of Jammu and Kashmir. Also, my lords, it used.
Representation
Yes.
goes away. I mean, the legislature itself ceases to exist.
Yes, my lords. And my lords, also the Ladakh Autonomous Hills Development Council Act 1995 provided for this Hills Development Council, which provided for decentralized autonomous bodies for governance.
And that has been rendered null.
Yes, my lords. Null and void.
All right, thank you.
This is also. Now, my lords, just 2 other short
Yeah.
points, and I'll make it very brief. One, my lords, so I should tell my lords, I appear in 2 matters, so that my lords has that. Writ petition, my lords, 1048 of 2019. Writ petition 1048 of 2019.
And you had it only that you are for as an intervener,
No,
Awami
but-
National Congress.
Appear in 2 matters. This is writ petition 1048 of 2019
And
and intervention number 138432 of
Yes, that we have.
2023.
138.
138432, my lords. 2023, that's the Awami National
I think
Conference.
maybe the nodal council will have to just update our sheet, because
Yes, ma'am.
just maybe you can update the sheet anyway, anytime today in the afternoon or evening. Just give it to the court master, because we,
Writ petition is Shakir Shabir and the IA is the Awami National Conference. Now, the reason why I'm mentioning this also, my lords, and I'm cognizant, my lords,
Yes.
of the last clock at the back. My lords, we're tuned to your lordship looking into it. But my lords, it's this, that in the writ petition 1048 of 2019, there is also a separate intervention. And that IA actually speaks to delimitation. And that's
Yesterday
I-
only, we said that that issue stands concluded by the judgment of my lord. This is
Yes. Now, my lords, respectfully, the judgment of your lordships, Justice O categorically states that the abrogation, the State Reorganization Act is not being challenged in this judgment. My Lord Justice Kaul knows that. My Lord Justice Kaul knows that. Therefore, my lords, and Justice Oak in that case also specifically says that counsel should have raised it initially, or it should have been pled in the petition. He says that in his judgment. And because it is not pleaded, we are not assessing delimitation in context of that. That is abrogation and reorganization.
We assessed the limitation, but we did not go into any other issue.
Yes.
Those issues
My lords,
were
may I just show you those?
How does unless there's a reference made or something, how does that issue crop up here?
My lords, because your lordships are seized of everything that falls out of abrogation and reorganization, including delimitation.
but that part is concluded by the judgment. I mean, there's no reference to this bench on that issue.
But my lordships, at that time, Justices Kaul
Somebody
and
should have come there then. We have heard other people there, whoever wanted to want delimitation. If this person was so keen, and that also, he's moved an application of intervention in this 1028 of 2019. He's not a petitioner. According to you, it's through
No, my lords, the same petitioner. This writ petitioner,
he filed a separate application.
yes, in his own writ petition, has filed an additional application vis-a-vis delimitation because it occurs subsequently.
This can't be in the form of an application in a
In
petition.
a matter of this nature, it becomes complex to get into this. We have to confine to what is there before us.
My lords, I follow and I bow down, but I will only say this, my lords, and your lordships may just, I will only say this, that at present, not only have the states been turned into 2 union territories, the delimitation exercise, which breaks down individual constituencies, which goes against that regional autonomous model of federalism promised in the Constitution of Jammu and Kashmir, is now rendered not.
That point you have made.
And therefore, I went through all those points to show that this is a unique model.
That's fine. That's
Now, if
That
you,
point you have made. Though.
yes, now if you've chopped up those constituencies, and that is what has happened, my lord, the chopping up of constituencies.
That will happen. Delimitation exercise always envisages inherently a change of constituencies.
My lords,
Otherwise, why have a delimitation?
but my lords, the respectful submission is that the delimitation exercise must either conform to the constitution's requirements.
Okay, that we were.
Yeah, or, and given that your lordships are seized of abrogation and the Reorganization Act.
That's fine.
That's that point you have made, that, this eats into the regional autonomous model of federalism. That point we have taken.
Wait.
Thank you, Dr.
My
Gulwat.
lords, just that, and then I'll end with this, my lords.
Manish Tiwari will call upon. Yes.
My lords, I'll just end with this one point.
Almost 30 minutes now.
30 minutes, my lords, it can't be. It's felt like 2 minutes. It's the best 2 minutes.
What is before us?
All right. Yes.
No.
Last was the point. Yes.
I'll just end with this, that part of this is that we made promises. We, the people, through our drafters, made promises. It is surely an axiom of decency, constitutional integrity, to keep our promises.
Thank you, Dr. Prasad. Yes. Now, Mr. Manish Tiwari. Yes, Mr. Tiwari.
May it please your lordships, our intervention application number is 160049 of 2019, in writ petition number 1013 of 2019. In the paper books volume, the intervention application is at PDF page number 409 to 420. And our written submissions are in the written submissions synopsis volume at PDF page number 610 to 644.
Volume?
This is the PDF volume on submissions, synopsis, and formulations, Your Lordship.
You represent whom, Mrs. Tiwari?
I represent Padi Richu, a former minister in the Arunachal government. And may I commence by answering what the Lord Chief Justice had referred to yesterday when we were going through the scheduling, that the 6 subparts of Article 371 are not before your lordships in this matter, and that is absolutely correct. However, the underlying principle of autonomy in Article 370 and 371 is more or less the same. And so therefore, what your lordships will hold in this matter, either way, will have implications on Article 371. And that is what I am here to respectfully point out. Your lordships, the Constitution of India, in addition to being a political legal compact, also served as a national security instrumentality in terms of unifying the periphery of India to the hinterland, because national security is not merely the use of the hard power of the state. Your lordships, when the British were ruling India, they actually managed the periphery through a process of treaties. And since there is a paucity of time, I will not lead your lordships through the various treaties in the northwest and the northeast of India. But independent India decided to manage its periphery, its realm, through constitutional guarantees. And the reason is because they were managing an empire and we were building a republic. And that's how Article 370, which applies to Jammu and Kashmir, which is a periphery state, Article 371, the 6 subparts which apply to the Northeast, and the 6th schedule of the Constitution, which applies to Assam, Tripura, and Meghalaya, becomes relevant and germane in this matter. And may I very respectfully point out, your lordships, that even a slight apprehension in the periphery of India can have serious implications And your lordships are currently dealing with one such situation in Manipur, and I will not belabor that point further. Before I come to the Northeast, your lordship, I just wanted to
I'm
point.
sorry for the interruption. Kindly give me a minute indulgence. And I have instructions to say this. But we have to be very, very responsible in assisting your lordships, and we must understand the difference between temporary provision, which is Article 370, and special provisions with regard to other states, including Northeast. The central government has no intention to touch any part which gives special provisions to Northeast and other regions. This submission would have a very potential mischief, and therefore, Lord, I am interrupting and making it clear. Let us confine to a temporary provision for Jammu and Kashmir. Rest are special provisions, not temporary provisions. So there is no apprehension, and let us not try to create that apprehension. I am not putting that apprehension at rest on behalf of the central government.
Your Lordship, may I very respectfully point out, I was not referring to the current central government. I was referring to the principle at stake.
So why should we deal with anything in anticipation or in apprehension? We are dealing with a specific provision, namely Article 370, which was applicable or is applicable according to you to the Jammu and Kashmir. We don't have to really expand this ambit on what the impact of our interpretation would have on other provisions of the Constitution.
Your Lordship, may I respectfully point out.
There is also another thing in what he says. This is a special provision, 370. 370 is stated to be a temporary provision. Of course, the councils have argued it is not temporary, that it was temporary in the context of a assembly. And all those aspects are the interpretation of 370. I think touching 371 is something which we should get into in these proceedings.
And particularly once, as a constitutional principle, the Solicitor General is informing us that the government has no such intent. Why should we apprehend that, this is what the government is about to do in other parts of the country?
Your
That's
Lordship,
not
may
before us, and I don't think we should really enter into that terrain at all.
Your Lordship, may I respectfully point out, you're absolutely correct, with regard to the
broader impact of, say, the abrogation of a state into a union territory. What could be the fallout in other parts of the country? Certainly that point has been made, that's present to our mind. But let's not now place specific focus on Northeast, that you will probably do this in the Northeast. I think the apprehension is allayed by the statement which has been made on behalf of the government. And beyond what was argued by the petitioners, namely that if you permit, and that is independent of Jammu and Kashmir, if you permit the abrogation of a state and its constitution into a union territory, why would it be confined only to Jammu and Kashmir? That point has been made. We have made a note of that. We will be hearing on the response to them.
Tiwari, just one. I think as far as the other parts of Northeast is concerned, because your written submission specifically talk about it. That, in view of the statement made, I don't think we are required to go into all that. One. Number two, as far as Article 3 and 4, whatever is there, if you have any submissions to make, just confine to those articles. The horse Northeast, that's possible. But otherwise, we are dealing with only 370 and Article 3 and 4.
Your Lordship, I am extremely cognizant of what has fallen from your Lordships. And I will try and confine my arguments to the constitutional interpretation, primarily because you were absolutely correct that while Article 370 has a subheading as a temporary or transitional provision, 371 and the rest of the provisions also have a subheading as a special provision. So therefore, I am not trying to equate temporary, which has been argued as permanent, with special provisions, but the underlying principle of autonomy, which runs through 370 and 371, is the same. And that's the limited argument that I want to make. So, Your Lordship, before I go on to the arguments with regard to the Article 3 and 4, may I very respectfully point out that
Mr. Tiwari, there are even certain special provisions with respect to state of Maharashtra also. State of Maharashtra and Gujarat. Why should, what we are interpreting is only 370.
Your lordship is absolutely correct,
Mr.
and
Tiwari,
that's why.
See, the interventionist. Basis is intervention, only on one principle. That is 371A. Once we are not touching that, what does the interventionist have to say in this matter?
And Mr. Tiwari, ultimately, you have nothing to say on Article 370. So then why should we hear?
Your
you on
lordship, may I
370?
just make a submission with regard to 370, and then, I will try and make a submission as your
But
Lord
there's
Justice
nothing that you
Khanna
have
said with
formulated
regard
in
to
your
Article
submissions
3
on
and 4.
370. You have not formulated anything in your submissions on 370.
Your lordship, there is a submission on 370 in our written submissions.
Let us
In
read
fact,
that and then we can close on that.
619 to 623 of our written submissions, your lordship.
With respect to different territory are different. There is no conflict. 378, one.
Your lordship,
A is
may I
different,
speak?
370A is brief.
Completely. May I, your lordship, may I be? Your lordship, may, Your lordship, may I make a submission with regard to 370, and then I'll go on to Article 3 and 4, which we have formulated in our.
Mr. Tiwari, what we'll do is we'll close your IA by taking the statement of the Solicitor General on the record, and we'll just close the IA right now so that, there's no ambiguity left in, on the adjudication on the IA or in the position of the union government on any of the states in the Northeast.
Well, your lordship, if your lordships on the statement which has been given by the union would like to close the IA, I have absolutely no objection to it. But may I just make one submission with regard to 370 with your indulgence? And that.
Tiwari, that's not what the applicant has come for. Applicant has come with some other basis. Whatever apprehensions may be in the mind, which was not subject matter here, is also allayed by the statement. Why should we, in these 370 proceedings, take up, you yourself says it's a very sensitive area. Why should we take
we'll
up?
Just say that the applicant, urging their submissions through Mr. Manish Tiwari, Learned Counsel, has urged that apart from the provisions which are contained in Part 21 of the Constitution pertaining to the state of Jammu and Kashmir, there are special provisions in the Constitution governing the Northeast in the same part. There's no his submission governing the Northeast in the same part. Full stop. Hence, it has been submitted that the interpretation which would be placed by this court on Article 370 may possibly impact upon the other provisions. Full stop. The Solicitor General has submitted on the specific instructions of the Union Government that the Union Government has absolutely no intent to affect any of the special provisions applicable to the Northeast and to any other part of India. Full stop. Next. The reference to the Constitution bench is confined to the provisions of Article 370 of the Constitution. Full stop. There is no commonality of interest between the issues which are sought to be addressed by the intervener and the issues which have been raised in the reference to this Constitution bench. Full stop. In any event, the statement which has been made on behalf of the Union Government would allay any apprehension in that regard. Full stop. We therefore close the IA we shall stand disposed of.
That's an addition to the well-settled principle that in constitutional adjudication, court will not frame a question that directly arise for adjudication. We will not stray into all those areas where court need not go into.
We'll just say, thank you. Ms. Varisha Parasad. Yes, Ms.
Very cognizant of the time and I'll be very brief. My lords have heard very lengthy arguments, so I want to start by a quote by the Soviet premier at the time, Nikita Khrushchev. And what he said was very interesting. He said, "You Indians are a remarkable people. How did you manage to liquidate the princely states without liquidating the princess?" So my lords, I want to start by saying that in fact, it was the constitution writing was a remarkable exercise, and the coming together of the Indian Union and the Indian Federation was a remarkable exercise. And it's in that context, and even the Soviet premier of the time, because it was not common practice. These nations were being born. And so my lords, I started with that. To come to my first point, I have 3 quick points and I'll try and make them very quickly. The first is about the concept of federalism as it operates in the context of India. And to that extent, my lords, I want to say that yes, at one level, Jammu and Kashmir is unique, but at the other level, it is also part of a federal union as federations are understood. And I want to take the example of the United States, because it's the first democratic country, federal country that comes to mind. And my lords, in fact, the US National Constitution is a very thin text. My lord knows that. It only has 7 articles supplemented by a total of 27 amendments. And it is importantly Article 1, Section 8 of the US Constitution that enumerates the specific powers taken over by the Congress and the federal level of the government, leaving all other spheres of autonomy to the states by default. This is the 10th Amendment, which expressly defines the status. So, my lords, my point is that federations, as we understand, can have a variety of permutations and combinations. There is no one kind of a typical state, even within federations, that can be envisaged. And my lords, my point then comes to Jammu and Kashmir, and how do we envisage states within the Indian Federal Union? My lords, there are various ways. One is we have a union territory. So, in a way, it's state minus. Then we have something, my lords have dealt with it extensively in the GNCTD case, that it is a UT, but with legislative powers, my lords. And so then you have something like Jammu and Kashmir, my lords, which is a state plus with its own constitution. And so a constituent assembly was formed and a constitution was given. So my lords, we must see that there are various permutations and combinations, and it is unique, but also a normal part of federalism. And my lords, there is a very important concept within federalism. One is holding together, and the other, my lords, is coming together. So and my main proposition is that while most of the Indian Union represents what has been called a holding together type of federation, where a multicultural polity with strong unitary features constitutionally splits autonomy between the Union and its regions to hold those regions together. However, Jammu and Kashmir represents much more a coming together federation, my lords, where previously sovereign polities pool their sovereignties and resources to come together and form a more secure and long-standing union. So it is within that we are envisaging the federalism that is envisaged for JNK. My lords, I have said, I've said various things in my note, it supplements it, but I'll quickly then come to my second point. And my second point is about the fact that when we look at Article 368, I'm saying let's forget Article 370 for a little while and the constitutional amending provision that 373 provides. Let's just look at Article 368. which is the constitutional amending power. Now, by their very nature, a constitutional amending power is far stricter than the normal legislative powers that even the parliament has. My lord, so therefore there are many checks and balances that Article 368 envisages, that is not envisaged in the general legislative powers that are exercised either by state legislatures or by the parliament. So my lords, therefore, when we are reading 370, so what is my point? My point is that therefore, when we are reading 370, it must be a very strict interpretation of what can or cannot be done. And therefore, when we are reading 370, it cannot be that in a casual manner, we are substituting one authority with another, as has happened in the constitutional orders that have been promulgated. My lords, I then come to, in fact, my Lord Chief Justice's question while I'm answering this. And my lords have read this article, I don't know how many times, 370, but may I please urge you to read it once more with me. Please, my lords, if you can come to Article 370 once more, because my lords have asked a very important question from all of us on this side, and that is that how do we read 2 and 3 and the Constituent Assembly part in it? And there's a clear answer for that. My lords, if we read, sorry, my lords, I apologize. Yes, if my lords can read para 2 with me once more, there's a clear answer. If the concurrence of the government of the state referred to in paragraph 2 of subclause B of clause 1, or in second proviso to subclause D of that clause be given before the Constituent Assembly for the purpose of framing the constitution of the state is convened, it shall be placed before such assembly for such decision as it may be taken thereon. My lords, I'm making a simple point that this was a transitional provision because of the fact that it uses the word before such assembly. It only provided a protection to place before the Constituent Assembly when a Constituent Assembly had not been formed. After that, the power that is vested in 2 was subsumed by 1. And therefore, it answers my lord's questions that are the subsequent presidential orders legal? Yes, they are, because they are not under exercise of power under 2, but under 1. And my concomitant point with that, my lords, is very respectfully. So our constituent, our constituent assembly makers, or our constitution makers were aware that at some point in time, the Constituent Assembly of J&K would have served its purpose and would no longer be there. And for that particular purpose, they had given that how can you make changes, and that was provided under 1, right, my lord? So therefore, they were equally aware that the Constituent Assembly would cease to be in power. Yeah. Yes, only before. My lord, I'm sorry if I'm moving very quickly, but I'm just cognizant of the time. My lord, so my essential point here is that the constitution makers were aware of the fact that the Constituent Assembly would finish its function and then no longer exist. And therefore, for making any changes, they had provided for the via media via 1. But for the abrogation, they only left it to the Constituent Assembly. My lords, there is no other way to reconcile the two. My lords, otherwise, how do we say that the presidential orders, and that's a question that has been falling from my lordships, I have seen very much from day one. And the only way to look at it is that clause 2 was a transitional provision, was only provided for, and my lords, there is logic in it. Because of the fact that before the Constituent Assembly was formed, the government would have needed concurrence because it was transitional. We did not know how exactly they represented, whether they represented the will of the people, etc. or not. And then after that, there was an assumption that the government of the day would be representing the will of the people. And so, at least with respect to certain decisions, at least with respect to making certain other parts of the the Constitution applicable to the state. However, equally, my lords, if we take that interpretation, then we'll have to set in time the Constituent Assembly and its power and the recommendation being necessary for the abrogation. My lords, because then it will reconcile. And my lords, just one very quick last point is the question, my lords, that even if we left everything aside, my lords, what happened on 5th and 6th of August 2009, and my lords are a constitutional court. My lords, 3 former chief ministers were in detention, and these are all facts, my lords. 3 former chief ministers, most of your legislative assembly, my lords, the will of the people is exercised by the Legislative Assembly, were in some form of detention or the other, either under the Public Safety Act or, my lords, under 107, 105. It's laughable. In Delhi, if, entire polity and all of the politicians who have actually supported you, who've been legislative members, are put in this manner. And therefore, I come to my last but very important argument that this is malice in law, because what this demonstrates, my lords, and how do we determine malice in law? By the actions surrounding the abrogation itself. And my lords, I'll just read very quickly because I don't want to burden my lords with reading anything at this stage. But malice in law is a very well settled principle. I'll just read it. And it has been held by this honorable court as follows. This court has consistently held that the state is under an obligation to act fairly without ill will or malice in fact or in law. Where malice is attributed to the state, and my lords, we are doing that, it can never be a case of personal ill will or spite on the part of the state. Legal malice or malice in law means something done without lawful excuse. It is a deliberate act in disregard to the rights of
read your
others.
submission below the quotation because that will help us.
Lords, it's there.
The abrogation of Article 317
Yes.
was effected secretly. You can read that, those 2 sentences there.
Yes, my lords. The abrogation of Article 370 was effected secretly, unilaterally, and coercively. Not only was the democratic process disregarded, but also the people and their leaders were kept in the dark, prevented from communicating with others, my lords, and even detained till the Union of India could issue them a fait accompli. In times when pre-legislative public consultations, my lords, and post-legislative social audits, my lords, we know that even before, there's talk of whatever law, there are public consultations and deliberations. But here, my lords, what has happened is that the will of the people has been trampled upon. And there can be no other reading in this regards, my lords.
Thank you so much, Ms. Faseth, I think.
Whom do you represent?
My lords, I am in IA 159055. Mr. Venkatesh Nayak.
Just want to know who is he?
My lords, he's an RTI activist. He's a very well-known and respected RTI activist. I'm so grateful.
Ms.
Your Lordship.
Yes.
My Lordship, I'm a little bit nervous because due to the time constraint, I will try to avoid repetition and try to assist my Lordships. Lordships, it's imperative, sine qua non, to slightly touch the provisions of 370, Concurrence 356 and Article 3, and federalism and democracy. Very briefly, my Lordships. And the circumstances under
Can we
which,
just run through your note?
very briefly, within 1 minute.
Let's look at your note. Let's look at your note. So it'll just bring clarity on what you want
Yes,
to
Your
argue.
Lordship. Your Lordships, and the circumstances under which instrument of accession was signed, and the letter to the Maharaja by the Lord Mountbatten, wherein he says that no sooner the normalcy returns, the will of the people will be ascertained. And I believe, Lordships, the will of the people was expressed by the Constituent Assembly, but by the J&K Constituent Assembly, and they framed the Constitution and defined the constitutional relationship between Union of India and State of J&K. My Lordships, the Constituent Assembly of J&K provides in Article 370, my Lordships, in 370 is a self-contained provision which prescribes very candidly that consultation with regard to the instrument of accession, the subjects mentioned, and by that reference, my Lordships, the instrument of accession is part of the 370, because whenever we take recourse to the subjects, we have to take recourse to the instrument of accession. My Lordships, I have in my submitted the document which I obtained under RTI with regard to supplementary instrument of accession signed by the other states. J&K is the only state which didn't sign the supplementary accession, only state. Your Lordship, 370 is the constitutional recognition to the instrument of accession. My Lordship, but the manner in which the concurrence, which is very candid, clear, my Lordships, express provision of the law, that concurrence means on the aid and advice of the councils of the ministers. My Lordship, the J&K Constituent Assembly in 1957 conveyed that the 370 will remain in the same form. They didn't recommend its abrogation. In fact, my Lordships, they recommended that it will continue as they pass the resolution. And my Lordships, the Constituent Assembly of the J&K temporary provision was only because it was left to the discretion of the J&K Constituent Assembly to take the final decision. Now, Lordships, the concurrence by the governor is not permissible under law because, my Lordships, concurrence affects the autonomy of the state. It's because of that reason the concurrence is to be given by the duly elected government. It cannot be the governor under the Articles 93 or 356 of the Constitution. My Lordships, the Article 3 of the Constitution says, view of the state. What happened in Jharkhand? 2 years, 3 years debate. Telangana when was formed? And with regard to J&K, 356 invoked, the relevant provisions suspended, which is unknown to law. And with regard to J&K, there was consent. My Lordship, I was a full-fledged state. I was having my own constitution, 1939, prior to the Indian Independence Act. And it's because of that reason, the other side of the Kashmir, which is with our neighboring country, they have right now, maybe on the papers, they have the Prime Minister, they have the President, they have the legislature. I'm functional democracy. I'm proud of it. I'm a nationalist. But Lordship, I take liberty to share with my Lordships. People make mockery of me. Is this democracy you're proud of? They have this full-fledged state. I was having within the constitution my prime minister, my Sadri Riyasat, my legislature. I'm reduced it to the UT, LG. Forget my Lordship about the prime minister. 65th amendment in 65, 6th amendment in JK Constitution, when Sheikh Abdullah was in jail. The amendment was made and this nomenclature was changed. Lordship, I'm concluding. Very important, Lordship, with regard to the will of the people, Lordship. The will of the people is of paramount importance. Federalism, rule of law, democracy, Lordship, is the soul of Constitution, basic structure.
held by in the Keshavananda Bharati case. Lordship, it's not mere elections democracy. It's beyond, it's vast, a functional democracy. My Lordship, will of the people is of paramount importance. I'm alive of the fact, Lordship,
Thank you, Mr.
courts
Lord.
are not to get
Thank
swayed away. I'm
Thank
1 minute only, Lordship.
Yes.
Courts are not to get swayed away by the emotions, but Lordships, here in this instant case, the will of the people, that is the Constituent Assembly of the J&K, the sentiments, aspirations, the desire of the people is intrinsic to the will of the people. That is to be looked by Lordships right now. Lordships, I'm concluding, but this is very important, Lordship. That is the report of state autonomy, which is the will of the people. This autonomy report is by, it's A290, volume 14, Your Lordship, document compilation. The government has set up, Your Lordship, it's very important.
What is the page? PDF?
Page A290, Lordship.
Can somebody give us the
Volume 14, Lordship.
1 second? Give us. All right. What is the point in there?
Point is, my Lordship, the state government set up a committee to examine the question of restoration of autonomy, the state of Jammu and Kashmir by government order number 196. Dr. Karan Singh is the head of the chairman of this committee. There are other members. Lordship, within 1 minute or so, I will conclude. This is the aim and object of this committee. However, other states exercise the choice. Yes.
549.
Page A2.
Yes.
How other Indian states exercise their choice, how they participated in constitution framing, and in what form did they adopt it, in not our concern. This shall be referred to whatever necessary in page to follow. But it's relevant to mention here that whereas other princely states signed the instrument of accession to India and subsequently the instrument of merger, the accession of J&K state was limited only to the areas of defense, external affairs and communication. Uniquely, J&K state is the only one to have negotiated the terms of membership of the union right till the Delhi agreement. It did not accept any provision of the Constitution of India other than those agreed to the instrument of accession and retained its autonomy. Autonomy has remained since the days of accession, the heartbeat of the people of the state. State has lost all resemblance to autonomy. Its erosion is the primary cause of Kashmir discontent. Keeping this in view, Shri Narasimha Rao, the then Prime Minister of India, announced in 1995 that the Union government would be prepared to consider autonomy short of independence for Jammu and Kashmir. Mr. Devi Gowda, as Prime Minister, offered Jammu and Kashmir maximum autonomy. The assurance was incorporated in this common minimum program of the National Front government. This is very pertinent, my Lordship. This is the autonomy resolution. Recommendations are there. This is by the state legislature. This is the will of the people. Lordships, Justice Sagir, a working group was constituted. One of important was headed by Justice Sagir. And the recommendation of that very committee was that the autonomy be restored to state of J&K. My Lordship, J&K was having its own constitution. This is embodiment of my emotions, desire, and aspirations, the J&K constitution. My Lordship provides the flag under section 144, which is made dysfunctional by the 273 CO, impugned COs. My Lordship, very briefly, Lordship, with regard to the which is very vital and very important.
The others who have to
Only 1 minute, Lordship. That is the Delhi
said that
agreement.
about 3 minutes ago, so I think we'll conclude. now.
1 minute,
Thank you.
Lordship. Only
No,
1 minute.
Thank you very much. Mr. Bhatt now. Mr. Bhatt, Mr. Zahur Ahmed Bhatt.
I pay Lordship, keeping in with the democracy, federalism, and the self-contained provision of 370, we pray that it's not sustainable, the impugned COs. So justice be done with the people of Jammu and Kashmir, Lordship.
Thank you.
Thank you.
Obliged,
Yes,
Mr.
Mr. Bhatt.
Lordships, I teach Indian polity to the students in Jammu and Kashmir. And it's very embracing and very difficult for me, like people like me since 2019. When we teach this beautiful constitution and beautiful democracy, and when they will ask, are we really a democracy since post 19 August 2009? since August 19. And it's very difficult for us to answer. Basically, it was very unbelievable on 4th August 2019, when despite the assurance of Honorable Governor, then Governor, that their Article 370 will not be abrogated, in the midnight, curfew is being imposed. All three chief ministers, cabinet
Can you
minister.
formulate your point? Just formulate the point now, because we've heard all this, almost for the. Also, I'll tell you why there are other people. Mr. Shankar Narayan has been waiting here for the last 12 days of hearing. Oh, how many days? 11? We have to give him some time. So please give us your specific point so we can leave some 20 minutes at the end. Mr. Beg has to argue for 10 minutes.
Within 2 days, 5th and 6th August, special state of Jammu and Kashmir was downgraded into 2 union territories, Union Territory of Ladakh and Union Territory of Jammu and Kashmir. These impudent actions are completely in violation to constitutional morality of Constitution of India, a right to democracy and consent of the people of Jammu, Kashmir and Ladakh, procedure established under the law, national interest of this country, cooperative federalism, supremacy of Constitution, rule of law. On 5th August and 6th August, Jammu and Kashmir had the legislature, which had basically the legislature of Jammu and Kashmir comprises legislative assembly and legislative council.
That point was made just this morning by Dr. Guruswamy. He's made the point.
What I'm going to tell.
Yes.
And
Don't repeat that, because that has already been made this morning. Just you are listening to it.
Yes, yes,
Same point has been made.
in legislative council,
Get on with something new. Tell us something new. And by Ms. Ramakrishnan also has made the same point in the morning.
I'm submitting legislative council is having 36 members. And it was not dissolved on 5th and 6th August. It was dissolved in October 2019. So it was in operation. Legislative assembly was dissolved in May 2018. So because the state legislature comprises legislative council as legislative assembly. On 5th and 6th August, it was there. So if we respect the consent of the people, which is federal, this is basic structure of the constitution. So there could have been option to get any concurrence from even a recommendation for this Reorganization Act from state legislature, which is mandatory. So part of state legislature was that. So when we see this was ignored. This was ignored and is not highlighted as on date. That legislative council, 36 members, they were also detained. Some of them were detained, some of them were not detained.
It is already
Yes,
it is already told to us by so many people that all 3 CMs, legislatures, they were all detained.
few were detained, few were not detained, because we don't have absolute this information. It was whole the state was under the blockade. Now, Lordship, when we go to Jammu and Kashmir State Reorganization Act, where Proviso 3rd is suspended, so it was mandated for that. So it was there is on.
All right. Thank you, Mr.
Very important submission. Proclamation dated December 2018. Dear President is knowing that this shows the intentions, because legislators, when we will get this Reorganization Act in the Parliament, there it mandates state legislature. We are clear before 1 year. In proclamation, Proviso 3rd is being suspended. Coming to the Article 371, important point which I want to highlight here. One is consent of the people was not respected, which is the very beautiful and basic structure in our constitution. Article 370, basically, it was, as Goswami, this ma'am said, that it was the constitutional intention of Constituent Assembly of India and Constitutional Assembly of Jammu and Kashmir. They issued them some guarantee, and Constituent Assembly of Jammu and Kashmir made the constitution. When Jammu and Kashmir constitution is framed, then, in my opinion, the proviso subclass 3rd of Article 370 has gone. That has no scope. So
we'll wrap it up now. Thank you very much. Yes, now Mr. Beg.
With one submission at last.
Please give Mr.
With
Beg
one submission at last. With one submission.
Yes.
We hope that this impugned actions, impugned orders may be cautioned, and question of 4th August may be restored to the state of Jammu and Kashmir.
Yes, Mr. Beg.
Obliged, Lord.
Second hour. बताएं उनको।
My lords, I must express my gratitude for you to give me some time. There was some misunderstanding. I had an advocate on record about a month back, and he didn't inform me that he had withdrawn. So I had to make very urgent arrangements and the kind of assistance which this honorable court deserves. In one day, I could not really come up to that standard. My lord, before I go to the present petition, I must inform my lord that this issue had come in 1982. There was a conflict between two parties in the Legislative Assembly on whether Article 370 should be made permanent or is it only transitory, temporary, because the sideline says temporary and special provisions. 370 has three temporary, transitory positions. So, my lord, there is a history behind that, why it was called 370 temporary, because either they were bound by our misfortune. Our Prime Minister had gone to United Nations with this issue about Kashmir, and they had passed a resolution, and they had said you should have a plebiscite. That resolution is still there. Thanks Lord, nobody is now after that United Nations resolution. It's for that reason that it had been called temporary. That's the only reason. Now, my lord, I'm seeking your lordship's permission, first of all, to refer to a scholar, A.G. Noorani. I know him personally. He had taken the permission from the Prime Minister to go into the archives and take out the documents which were confidential. And then he, my lord, wrote this book. It was not out of imagination or out of some sources like me and others or some politicians. It was with the sanction of the government of India that he had access to these arguments with my lord. Now, I first of all, my lord, if your lordship have volume 20 books -F, I'll be reading from that. I think your lordship have that. Volume 20 books -F.
What PDF page will that be?
It says, my lord, article.
Yes, you got that. It's at page 1, volume 20. That's Mr. Noorani's book.
Yes. Article 370 of the Constitution of India relating to the state of Jammu and Kashmir. Jammu is missing, is now, that time it was 60 years old, now it is much longer. The Constitution came into force on 26th of January 1950, which our children celebrate every year, this 26th of and 15th of August. 26th of January 1950, and with it, this unique provision. All other provisions were debated in the Constituent Assembly of India after deliberations in its drafting committee and sometimes discussions in the Congress Parliamentary Party. Article 370 was discussed for 5 months by the Prime Minister of India, Jawaharlal Nehru, and his colleagues with the Prime Minister of Jammu Kashmir, Sheikh Mohammed Abdullah, and his colleagues from May to October 1949, and then the reference is there. The state of Jammu and Kashmir is the only state in the Union of India which, my lord, negotiated the terms of its membership with the Union. The reason for that was Mr. Jawaharlal Nehru's Security Council resolution which said that status quo should be maintained till they decide which party is right. The Constituent Assembly merely put the imprimatur of its approval on 17th October 1949 to a draft agreed between the Union and the state. Article 370 records a solemn compact Neither side can amend or abrogate it unilaterally except in accordance with the terms of that provision. The Union Home Minister, Your Lordship may forget that, and move on to the next one on page 2. A little over a decade after, it is the second paragraph, a little over a decade after the enactment of Article 370, its co-architect, Prime Minister Nehru declared in the Lok Sabha on 27th of November 1963 that Article 370 within quotes has been eroded. If I may use the word, and many things have been done in the last few years which have made the relationship of Kashmir with the Union of India very close. There is no doubt that Kashmir is fully integrated. And that integration was not only constitutional, it was also emotional. It was also based on certain principles. Kashmiris rejected the idea of Pakistan. Some fresh steps are being taken, and in the next month or two, they will be completed. We should allow it to go on. What had happened in the next couple of months, Sheikh Abdullah was arrested. We do not want to take the initiative in this matter and completely put an end to Article 370. That was in his mind that in some form or the other, it should stay there, maybe for emotional reasons. There was no need for that, as the Union Home Minister Gulzari Lal Nanda explained in the Lok Sabha on 4th of December 1964. The only way of taking the Constitution of India into Jammu and Kashmir is through the application of Article 370. It is a tunnel. It is through this tunnel that a good deal of traffic has been passed. It is a one-way tunnel, and we are not unhappy with that. He pointed out that while the normal process of constitutional amendment is subject to stringent conditions, the process of amendment made available under Article 370 is very simple. It's a pragmatic approach. Why to have a constitutional amendment from time to time? If you can pass an executive order through 70, why not resort to this? Sorry, sir. In regard to the rest of India, if a state's power are to be curbed and correspondingly those of the Union enlarged, the elaborate procedure laid down in Article 368 will have to be followed. In regard to the state of Jammu and Kashmir, Nanda argued a mere executive order made by the president under Article 370 would suffice. His successors in office accepted this interpretation of Article 370. Except, my lord, as your lordship will see, that is a tunnel. It is a tunnel, all right.
It appears that Mr. Nurani's thesis is substantially in terms of what Mr. Dwivedi argued. Because Mr. Nurani also says that once the Constituent Assembly of J&K was dissolved and the Constitution was framed, then Article 370 came to an end. And then everything he says that happened thereafter is unconstitutional.
Yes, my lord, I endorse that, madam. Nanda concluded what happened is that only the shell is there. Article 370, whether you keep it or not, has been completely emptied of its contents. Nothing has been left in it. Now, your lordship may kindly turn to is it page 3 and para 2. The Indian Independence Act empowered the Governor General of India to adopt the Government of India Act 1935 as the interim constitution till the enactment of a constitution by the Constituent Assembly of the state. That act, as adapted, served as a constitution from 15th of August 1947 to 25th of January 1950, my lord. Then, my lord, the last 5 lines of this page, the Governor General had written a letter, stipulated that as soon as law and order have been restored in Kashmir and her soil cleared of the invader. No, some years back, those invaders came, my lord, as not just invaders, but as militants, but as terrorists. The government of India made it clear that they would regard it as a provisional until such time as the will of the people of the state.
What is the drift of what you're arguing? I mean, what is your contention? What is your submission?
My submission, my lord, is finally this, that when all these documents and orders are studied, the abrogation of the state assembly, the abrogation of all its institutions, abrogation of Article 370 is unconstitutional, unnecessary. It's just a political gimmick. That is, my lord, the pith and substance of my argument. Then, my lord, clause 7 of the instrument of accession will show that in the beginning, our accession was on one extreme. And now it has gone from the one extreme to another extreme. In the beginning, my lord, according to the white paper on Jammu and Kashmir, published by the government of India early in 1956, recorded, in accepting the accession, the government of India made it clear that they would regard it as purely provisional until such time as the will of the people of the state could be ascertained. Lord, then I might, my Lord, go to the next page, the second para. The state had acceded to India 1947 in respect of only of defense, foreign affairs and communications. Negotiations were held on 15th and 16th of May 49 at the Deputy Prime Minister Vallabhbhai Patel's residence in New Delhi on Kashmir's future setup. Nehru and Abdullah were present. Foremost among the topics were the framing of constitution for the state and the subjects in respect of which the state should accede to the Union of India. On the first, Nehru recorded in a letter to Abdullah on 18th May that both Patel and he agreed that it was
possible to formulate, because you formulated it in your submissions instead of really reading us through Mr. Nurani's book. We'll certainly look at Mr. Nurani, the book, and all the other material which has been given to us. If you could just formulate now your points really, because a lot of this ground has been covered by the council preceding you.
Yes, my lord. Okay.
Almost everything has been covered.
It's a submissions, but anyway, I think since my lord want to go to the bottom of it, but in a very short, my lord. पेज है इनके पास
In fact, we made a request.
No paper, please. Yes.
My lord, before I go to this, my lord, the written submissions, I have also written submissions. In this issue arose for the first time in Supreme Court of India in 1982. In a presidential reference, my lord. There was a dispute in the Legislative Assembly of Jammu and Kashmir which was also its constituent assembly. A dispute arose whether Article 370 should be changed or modified. That was the issue. My lord, this it went to the Supreme Court. At that time, my lord, I was vice chairman of a political party, and I submitted, my lord, a written note. It is here, my lord, I'll pass it on. In this, my lord, if your lordship see that after the lordships heard us, the simple order was, we don't think it necessary to intervene in this matter. And that's how it stood. That's why nobody was bothered about it. After about every month and every 2 months, one entry or the other was, my lord, brought through Article 370 into Jammu and Kashmir. And when Sheikh Abdullah objected to it, my lord, he was sent to prison for 19 years. And his deputy, Bakshi Ghulam Ahmad, was taken into confidence. When he stopped playing the game, he was removed. And Bakshi Ghulam Ahmad Sadiq was made the chief minister, maybe without majority. No, my lord, this is a tragic story. And finally, it has landed here in this August House for a final say. If this article, as some people have said, my lord, that this article is useless, but there is something more than bread and butter for human beings, whether they are people from Jammu and Kashmir, Jammu or Kashmir or Ladakh. They have, my lord, they were born with the idea that somehow we will be well protected, we have special rights under 370. Article 3 was amended by the impugned legislation, and totally contrary to the provisions of Article 370, Ladakh, Jammu and Kashmir was broken into 3 parts. Governor was replaced by Lieutenant Governor, who is a gentleman of the highest order. There's no doubt about that. But how can 370 be abrogated? What was the mechanism? First, ask the governor to dissolve the Legislative Assembly of Jammu and Kashmir. For what reason? Nobody knows. He just passed the order at around 12 o'clock at night. The certain orders were then issued by him. After some time, he was transferred without any reason and sent to a God-forsaken place. And what he said thereafter, I didn't bring it on record. This is step 2. What is step 3? You pass an order by virtue of which the Constitution of Jammu and Kashmir is abrogated. And you pass that order under Article 370. After that, what's the next step? You abrogate Article 370. Now, I'll pass on the documents to my lord, if your lordship are pleased to, all the documents which are, my lord, necessary. If I really go into details, my lord, I will take more time than my class fellow, Mr. Kapil Sipal, had taken. But since your lordship have set a deadline, I must accept the guillotine and say that thank you very much.
Thank you so much. Thank you. Thank you, Mr. Dey. Thank you very much.
On record.
Thank you, Mr. Dey. Thank you, Mr. Dey. Mr. Shankar Narayan, what will be done?
You cannot be, permit me.
You're now the final counsel on your side. We'll give you half an hour from 2 to 2:30.
My lord, have information to place on record.
Why didn't just Mr. Shankanaran just tell the nodal council to circulate what Mr. Beg gave? Just circulate it in the form of.
The earlier advocate.
No difficulty. No, we have a nodal council who will scan it and just make sure that it's on our record. No.
These orders from our house.
No difficulty.
Actually.
Naturally. So Mr. Shankanaran, we'll hear you 2 to 2:30, but precise, I know you'll be able to do it in half an hour and then. Yes. You want the temperature to be increased a little?
Yeah. Every one of us, it's very chilly.
All right, I'll.
The warmth of the
My lord, their attendance may be recorded.
Certainly, certainly.
Their presence may not be.
We'll be back at 2 o'clock. Thank you, Mr. Beg.